Dear students, we will discuss trademark in this particular class. This is the second category of intellectual property law, and we will see the basic principles of trademark. What's as I already told you that we are going to discuss it out of these 7 categories of intellectual property law. And what is a trademark? And trademark is nothing but a unique mark which is identifying a particular company or a service and distinguishes it from its competitors. And also this particular intellectual property has to be registered or by usage they get the trademark registration, and it provides exclusive right to use, to license, to sell this particular mark, and again this particular mark is protected for a limited period of time, that is 10 years, and which can be renewed from time to time. So, these are some of the trademarks which you can find and which you can easily identify the company which belongs and even the products or services which they are offering. And so when we are looking specifically into these registered trademarks, and it is a matter of reputation of each company. At the same time, even point to the category of goods which they sell. For example, the Nike, everybody knows that it is a sports goods and apparel, sports apparels which they are specialized in. So, it means that if you can identify a particular service or a particular goods or particular company with the registered trademark, that is the objective of the trademark. And you can find a number of trademarks, registered trademarks which belongs to different companies, and these trademark, the registration of the protection of this particular category of intellectual property add to the reputation, add to the intellectual property of those companies. For example, Coca-Cola says its trademark is worth about 60 billion US dollars. So, the trademark valuation can add value to your company, add value to your reputation of the company, add value to the reputation of your product, and definitely you can find some of them, and there are different kind of trademarks which you can find it. How you brand it, the products you can brand it in such a way. At the same time, why we have to register the trademark. So, you can see these 2 pictures, and one is Coca-Cola is a famous brand, is a soft drink, but you can find this we call it as duplication or deceptively similar, which the other companies can come up with the trademarks which is similar, deceptively similar, and so that they can leverage the reputation of Coca-Cola, the existing product. And the second picture which you can see that the Starbucks, the famous the coffee chains all over the world. So, it can be Coca-Cola, or it can be these other coffee. So, the Starbucks can be some other bucks. So, the similar appearance is once it is registered trademark, you protect your intellectual property, and deceptively similar or similar trademarks are not allowed under the trademark law. So, you can find what is the menace of the famous brands. Once your brand become famous and others also want to take economic advantage of your branded product. So, whether it is it's a water bottle, or whether it is a famous brands, and whether it is a product, it depends upon the market of the product as well. So, once it is registered, it is your intellectual property. So, simply by registering its trademark, you can avoid this kind of duplication by deceptively similar trademark by others, and also sue others for damages to if somebody uses the deceptively similar trademarks. So, you can see the why this the similarity between these 2 trademarks. So, everybody knows about Adidas, what is the brand is all about, but you can see the Abibas as well. So, always people want to take advantage of the famous brands. So, if it is a registered trademark, then definitely you can file suits against those who are duplicating your trademark and trying to get economic benefits out of your trademark. So, I am just showing some of them, and it is interesting to see all these the markets, all these are happening in the markets. So, in order to avoid, you have to register your trademark. So, what can be registered as a trademark? Basically, trademark can be letters, it can be numbers, it can be words, it can be colors, it can be a phrase, and it can be a sound, it can be a smell, and it can be a logo, it can be a shape, it can be a picture, and also it can be a aspect of packaging or any combination of all these, where it can be letters, pictures and smell and sound and all combination also can be a trademark. Then you can see that these trademarks can be registered for goods or services. So, the generic terms are not permitted to be trademarked. For example, the names of the places are prevented from making trademarks. And again, so it is registering names are prohibited to register as trademarks. And again you can see that the kinds of trademarks, there are different kind or different categories of trademarks which you can find, that is the marks on goods, then you can find service marks, you can find certification marks, you can find collective marks, and you can find well known marks, and also you can find trade names. All these are the subcategories of trademarks. You see the example of different service marks, which definitely these marks shows the service which they provide. For example, Visa, and everybody knows that what service which the Visa provides, and these are specifically known as the service marks. And then you see the certification marks. For example, the BIS marks, the BIS hallmark, and everybody knows that it is a certification mark for gold. And also you can find the ISI marks for different products, the food products order mark, it is AG mark for agriculture products. All these are certification, subcategory of certification marks. And also you can see the collective marks, and collective marks which includes, for example, the collective marks of Lions Club, which you can find it, and then certification mark, wool mark, which you can find it as certification marks. And then another category is the well known marks. So, because of that particular products are well known in the market, for example, Coca-Cola and Toblerone, that is the triangular chocolates. Then names also which you can find it, the famous trade names of Godrej, which is very famous for furnitures, refrigerators, doorbell, and also the G. So, you can find the electric products of G. So, all these are well known marks, which is known as well known marks, and even you can find sound marks. So, the famous the mark which you can see the the sound mark. So, which you can find it another category of trademarks. Then the new categories are also coming up, which are smell marks. So, for example, the perfumes which identified specifically on some smell marks. So, these are also subcategories of the trademarks. Then and also you can find some of them in the name of trade names, that is the distinctive symbols names. So, that help the consumer to distinguish between the competitor goods and services. And here the trade name, so the enterprise name is always in consumer's mind. For example, the name of Tata. So, always there are the company's name is in the consumer's mind. So, this is actually nothing to do with the quality, but it is directly connected with the name of the company which holds the reputation in the market. So, at the same time the consumers expect a particular quality of products from these particular companies as well. At the same time, if you look into these forms, which we already said that we can find it in the form of visual marks, you can find in the words, letters, numerals, or a combination of all these together in the form of 2D as well as in the form of 3D signs as well, which you can find it. I already said that even the audios in the sound mark and musical notes also can become a part of trademark. And olfactory is a subcategory on smells, which you can find it as a smell marks. And also, what is actually protected in trademark? And the trademark, which gives an exclusive right to the trademark holder of goods or services which are registered and protected. So, this can be licensed, this can be sold, this can be assigned. So, any other intellectual property, you can make economic benefit out of this protection of this particular marks. And there are exclusions as well, which you can find it as state emblems and official hallmarks, emblems of intergovernmental organizations. This cannot be marked, this cannot be registered as the trademarks. And then protectability is you can find some of the criteria of the protectability, the basic functions, and also the trademark you need not be always register it, but it can be also acquired by use, acquired by always by use as well. And the trademark should not be deceptive, it must be non-deceptive. It simply means that it avoid misleading, it should not be misleading and not contrary to the public order or morality. And the special requirements, as there are special requirements as to the specific categories of trademarks as well. For example, in the case of smell marks, so there is specific requirements are there. And you can find it the simply the functions of trademark is to the source of origin of goods or services or to the reputation of the company which sources trademark. And also these trademarks which assures the consumers of certain quality of goods bearing that particular mark, because always the consumers in mind that this particular trademark which belongs to a particular company produces certain quality of products. So, the expectation is very high on the consumers always, and in a period of time it creates the business goodwill and also the brand awareness. It is a tool of marketing as well. The trademark is a tool of marketing as well. So, it have the trademark as an intellectual property have multifarious functions it is to perform. It is not only directly related with the reputation of the company, product, its goodwill, its brand and many more is related with the trademark. And now the companies have started innovative branding with the humor sense like for different products. So, you can find these some of the marks which the companies have started new marketing strategies with pictures. So, you can find it with like cartoons, they are using it different trademarks as a tool of marketing. So, it means that all these are intellectual property which is contributing to the trademark and contributing to the company. And always this can be found some of the companies like Origins, one of the advertisement which they give with a matter of humor, they advertise it, their trademark, they advertise it with a sense of humor. So, now the companies are using trademark in different ways to market their products as well for innovative advertising in different publications. So, that they can promote their particular products with a touch of trademark. And so, you can find this this particular company Origin, how they advertise the trademarks for their in different ways which they can advertise their trademarks. So, if you look into these some of the cases there are you can find a number of cases in different jurisdictions. I thought that I will cite some of the cases from India. So, you can find these cases Sony is a trademark for everybody knows that Sony is good for what different categories of products, but what about other products? For example, the name is they put for somebody, or the Sony name which is not related to that particular product at all. for example, the Sony for nail polish, or Sony name for the frames of spectacles or goggles, or also the other names, whether it is a name, actually whether it is a surname, it is a common surname in India, whether Sony can sue. So, in most of the cases the court said that the Sony cannot sue the Indian other products with the name Sony, because this is mainly because this particular company is producing a category of products, very specific products. If it is nothing to do with it, they cannot claim that particular name as such, because once it is it's become a generic name, and if it is a generalized name, so it is very difficult to preserve it as a trademark, but they can preserve it. But the advantages you can see from this particular pictures, what is the advantages of trademark. If it is a registered trademark, so there will be so many Fair and Lovely will be produced by the competitors with similar names, deceptively similar names. So, if your trademark is registered, so you can protect your intellectual property against others and claim huge damages. So, it is very important that you should register your trademarks. So, you can find a number of products. So, once if there is any kind of confusion in the mind of the consumer, then definitely you can sue your competitor's product by protecting the trademark as an intellectual property. So, trademark is a very important category of intellectual property to be protected, because it protects your company from the deceptors, it is protect your company from the reputation of your brand, it protects economic benefits, and you can assign it, you can sell it, you can lease it, and it is you can say that it is a bundle of his rights or consent is associated with the trademarks. This is another case which come up before the Indian court. So, in India, so you can see the one of the undergarment which put their name Benz, and you know that the Benz is very famous for what? It is definitely a very luxurious vehicle. So, the Benz has sued this particular company, the undergarment manufacturing company. What happened in this particular case is the Delhi High Court very clearly said that this is deceptively similar, because you can find the similarity in their appearance. The products absolutely is nothing to do with the original Benz, but it is used for an undergarment, but this court in this particular case said that this is deceptively similar, and the company, the TTK products, cannot use this particular trademark for marketing this particular undergarment. So, you can see these cases also shows, and you can find a number of cases, but these cases shows the jurisprudence. There is ample jurisprudence in India and other jurisdictions on trademarks. It clearly says the trademarks are territorial in nature, and the trademark protection, like any other intellectual property law, is not global in nature. Every intellectual property is territorial in nature, not global in nature at all. So, the protection is confined to the territory, the specific territory, and so it means that the courts will grant injunctions very specific to the territory at question.